All right, once the jurors are ready to be brought in, they can enter the courtroom, please.
Yes, Your Honor. All right, please. Here's our President counter for you, Your Honor.
Thank you. Please be seated. All right. Good afternoon, everyone. We are back on the record on case CR 2221-1623, State of Idaho versus Chad Guy Daybell. The court notes that earlier this afternoon, the jury returned a verdict of guilty on several counts that are subject to this capital sentencing phase, including in the verdict form counts 1, count 2, count 3, count 4, count 5, and count 6 of the amended indictment. The court at this time then is going to commence with the capital sentencing phase. I'll note that in this case, the jurors have returned, including the juror alternates that are here as well, and the 12 jurors who returned the verdict under Idaho Code 192515 subsection 5B. The court is using the same jury to conduct this phase of sentencing also, and that statute reads that if the defendant's guilt was determined by a jury verdict, the same jury shall hear the special sentencing proceeding. So we are in that special sentencing proceeding. As I mentioned, the jurors are here and present. And ladies and gentlemen of the jury, thank you for continuing your jury service. You've again been seated for your continued service in this case, and that's the matter we're taking up at this time. To give you an idea of just the schedule, the court has some preliminary instructions that are going to be read to you this afternoon. We're going to commence then with further evidence on the sentencing phase starting tomorrow morning after I read these preliminary instructions. And the court's proposal on our typical scheduled plan would be to start at 8:30. Is the state going to be ready to proceed at 8:30 with any impact statements that may be offered?
Yes, Your Honor.
All right, that's how we'll run the scheduling at this point then, and I'll inquire as to the jurors going forward. Also, the scheduling we'll have during this phase of the proceedings. They don't need to be limited to the timeframes we've had throughout the trial, including, depending on how long this takes, weekends. So I am essentially leaving up to the jurors their proposed schedule within reason of when we'll work through this proceeding. So the court is going to read some preliminary instructions then to the jurors. And again, you'll receive additional jurors when you retire to deliberate on this part of the case. But for now, the court will just read these and those will be included with you later. So in this case, the defendant in this case has been convicted now of the crimes of first-degree murder and conspiracy to commit first-degree murder. We will now have a sentencing phase of the trial regarding those offenses. Additional evidence may be presented during the sentencing phase. You should also consider the evidence presented during the trial. Before the death penalty can be considered, the state must prove at least one statutory aggravating circumstance beyond a reasonable doubt. If you unanimously decide that the state has so proven one or more statutory aggravating circumstances, then you must decide whether the imposition of the death penalty would be unjust by weighing all mitigating circumstances against each proven statutory aggravating circumstance. At a separate proceeding, the court will sentence the defendant for other offenses of which you have found the defendant guilty. Instruction number 2. Your duties are to determine the facts, to apply the law set forth in my instruction to those facts, and in this way to decide the case. In so doing, you must follow my instructions regardless of your own opinion of what the law is or should be, or what either side may state the law to be. You must consider them as a whole, not picking out one and disregarding others. The order in which the instructions are given has no significance as to their relative importance. The law requires that your decision be made solely upon the evidence before you. Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted during this trial and during the sentencing phase. The production of evidence in court is governed by rules of law. At times during the sentencing phase, an objection may be made to questions asked a witness or to a witness's answer or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the sentencing phase, I may have to talk with the parties about the rules of law which should apply in the case. Sometimes that will occur at the bench. Other times you may be excused from the courtroom so that we can discuss those matters. You are not to speculate about any such discussions. They are necessary from time to time and help the sentencing phase run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with those terms. You are to consider all the evidence admitted during the trial and during the sentencing phase. However, the law does not require you to believe all the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. If any evidence is admitted for a limited purpose, you are not to consider it for any other purpose. There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all the experience and background of your lives. In your everyday affairs, you determine for yourselves whom you believe, what you believe, and how much weight you attach to what you are told. The same considerations that you use in your everyday dealings in making these decisions are the considerations which you should apply in your deliberations. In deciding what you believe, do not make your decision simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you hear and decide how much you believe of what the witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to give such opinion, you should consider the qualifications and credibility of the witnesses and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. Instruction number 3. It is presumed that no statutory aggravating circumstance exists in this case. This presumption remains throughout the sentencing phase and during your deliberations. The state has the burden of proving the existence of a statutory aggravating circumstance, and that burden remains on the state throughout the sentencing phase. The defendant is not required to prove the absence of any aggravating circumstance, nor is the defendant required to produce any evidence at all. The state must prove the existence of a statutory aggravating circumstance beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. That in this time then concludes the initial preliminary instructions for the sentencing phase. And the court is going to be in recess then until 8:30 in the morning, when we'll commence with evidence on that phase of the trial. Before we break for the day, does the state have anything further?
No, Your Honor. Thank you.
Anything further from the defense?
Nothing, Your Honor. Thank you.
All right, thank you. I'll note that the jurors will remain sequestered during these proceedings and will begin again tomorrow at 8:30. Thank you again for your continued service, and that will conclude our matter for today. Thank you.
All right.